Welcome to the Tricord Advisors podcast. This is where we answer your questions to help you get excited about your finances. This is Randy Barkley, and I'm Jeremiah Lee. We're both certified financial planners, and I'm also a California licensed attorney.
The Secure Act and then the Secure Act 2.0 had a dramatic effect on required minimum distributions. In other words, if you have an IRA, if I have an IRA and I want to give money to you, it's no longer, you can't just take it over your lifetime, your expected lifetime. There's all these changes in Secure Act 2.0 that was just passed. It changed everything. I mean, it really threw everything up in the air.
Yeah, this is for people who have inherited, a big one, there's a lot of RMD changes, but the big one is if you've inherited an IRA from your parents, from someone else, it used to be that you could take that money out over the rest of your life.
Right.
It was a nice little benefit. Whereas now they've changed the rules and they've changed them all over the place. So to tell someone, hey, how can I take this out? The answer is we need to sit down and look at the details.
And it's not just you, it's your family, what you're trying to accomplish for your family. Yeah. It is really critically important that you have all those details so you get the right beneficiary designations. And I think it's important for you because of your legal background. A lot of people think, well, this is just in my trust, so this will just follow my designations or my distribution based upon my will or my trust. And
it doesn't. It's good for people to know that a trust or a will controls your state.
Right.
So your home, perhaps some checking accounts if they're in your name, anything you put in the trust. But retirement accounts, qualified accounts, they go by your beneficiary designation. So whoever you list on that kind of contract, that piece of paper, that's where it's going to.
I mean, for our listening audience, we have a client who the man who set it up named his trust, and there wasn't the right trust, and he's now created a real mess for his widow because of the way it was done. And of course, you can't go back and correct those documents after somebody dies.
Yeah.
So it's really critically important that we take a good hard look for our clients. We're constantly reviewing their beneficiaries.
And to keep this stuff up to date, not just who's named, but how the money is supposed to flow. We've talked about it before. Someone who's a very wealthy family, they might take a retirement account like this, and instead of naming their kids, they might name their grandkids.
Their grandchildren.
And say, let's skip over here. Let's let the grandchildren receive this, stretch over their lifetime.
Because so for people listening to us, so the reason they would do that is that their grandchildren, before the law was changed, if granddad died, the grandkids then would get this distribution over their lifetime. So if you had a grandchild who was, let's say, in their 20s or 30s, they would get distribution over potentially 50, 60 years.
Which gives the money a time to grow and expand in a tax-free environment, which is great.
And what's happened is that's all gone away.
Yeah.
Grandchildren are specifically excluded from the distribution pattern, right?
That would allow them to get that, they call it a lifetime stretch.
Right.
That would let them stretch over their lifetime. They are out. And so for most people who are inheriting an IRA, if someone's parents or grandparents pass away with an IRA and you're inheriting it, you're likely, again, there's so many caveats here, but you're likely enough to take it over 10 years.
Right.
And meaning that the government wants you to get that money out of that tax-free environment. It comes out as though it's income, so you get taxed on it, and then you receive it. For some folks, no big deal. I'm going to use the income anyways. It's great. For a lot of people, they're in their highest earning years. If you're in your 50s or 60s, still working, and now you have, if your parents pass away and you inherit something from them, now you have all this income on top of that you don't have a choice to elect to defer or to push it off. So we're going to talk about that today. We're going to jump into some of these rules. And there's a lot.
There's a lot. I mean, we're not going to be able to get through all the details. In fact, we'll bore our listening audience to tears if we got down into the weeds with a lot of this stuff. But basically, it comes down to two things. So when did an IRA owner die? And where did the IRA owner die before or after his RMD? Was he taking them or not taking them?
Yeah.
So there's these are really critical dates.
Yeah. Let's start with the first one. So when they died, if somebody died in 1990,
right,
the old laws apply. We don't have to worry about any of this stuff. Whatever the law was in 1990, that's what's happening.
So it's grandfathered in.
Yeah, grandfathered in. You don't have to change things. You don't have to go back and readjust it. However, from 2020 forward, if anyone dies past 2020, so now or in the future.
Remember the Secure Act, the first one was passed in 2019. And the other one came in, 2020, right?
Okay. 2022, just recently.
22, yeah.
So it took effect 2020. So anyone dying 2020 or later is going to be under these new rules. So that's the first one, is when did the person pass away? The second one is say, okay, if you're under the new rules, if they've passed away in 2021, 2022, and you're now inheriting an IRA, the next question is, the person who passed away, were they already taking required minimum distributions from that account, or were they before that age, which that age was generally 72? again, that also got changed, right? So you have to come
Right.
in and do some math to figure out
Right.
what age they were, what they were taking. And there was a lot of confusion here. And a benefit is that the IRS had to pass some rules to give people waivers, to waive the penalties, to say that there's so much confusion about what you're supposed to do that it changed. So what some people thought was an inherited under the new rules. So if someone passed away in 2021, they received this inherited IRA. A lot of people were not taking RMDs.
Right.
And the way the rules were written, that's what we went on as well, to say you don't need to take these. The IRS then came out with some later rules to try and clarify, to say if the person who passed away was already taking RMDs, whoever receives it has to continue taking RMDs based on the recipient's age. Again, a lot of complexity built in that.
There is, I mean, we're just trying to get to the highlights of the things that people need to be aware of. And the bottom line is what we want to emphasize is you need to check your beneficiaries. You think you've done it, and we find it often again, time and time again, that people have not really gone through and analyzed their beneficiaries, because it does not follow your trust or your other estate plan, like your will.
Yeah, and they should for sure be coordinated.
For sure.
But a lot of people think that because I did a will once or I did a trust once, everything is covered, it's fine.
Yeah.
I'm just going to close the book. But really, you're right. It's a good moment to really examine these things, make sure they're coordinated.
So let's talk about who is covered under the new act. I mean, obviously the first one is the surviving spouse.
Yeah. But rather than using, they have some very specific terms that get confusing. We'll just say that this golden group, this very special group,
I like that,
is your spouse. If you pass away and your spouse inherits your IRA, they get to pretend it's theirs. They get to stretch it out over the rest of their life, kind of acting just like it was you. It's the golden group.
Those rules have remained the same.
Yes. So for someone who is permanently disabled or chronically ill, they'll have some exemptions there.
So minor children they get the stretch until they're 21, but exclusively it prohibits naming grandchildren. Mm-hmm. So if the IRA owner, the participant, names a grandchild as the primary beneficiary, is excluded on the rules. They're not eligible designated beneficiaries. But a minor child of the account owners, they get the stretch until they turn 21, and then it goes to the 10, right? That goes to the 10 year.
Yeah. So if I were to pass away and my kids inherited an IRA from me, they would be able to use their lifetime stretch until they reach 21. And at that point, then they have the 10 years, which is a benefit. It allows them to preserve a lot of that capital and not be forced to take it out.
And the next one is disabled. Yeah. So if you have a child that's disabled as a primary beneficiary, there's very strict rules under the IRS that determine what a disabled person is. So we call it acid test. They have to meet this acid test by the IRS rules to be qualified as a eligible beneficiary under this rule.
Right, to go through.
And the other one is chronically ill individuals. So if you named a child, or let's say somebody that it was terminally ill or chronically ill or something like that, maybe had like MS or something like that. Again, there are
specific rules. Yeah,
specific rules. And individuals not more than 10 years younger than the IRA owner, or beneficiaries who are older than the IRA owners, plus it just gets really complex. It just keeps going down in the weeds.
Right. And I see this one, that last one, the primary purpose is to cut out children. They're making it clear that if you want to pass this to your kids, you're not going to get that lifetime stretch.
Right.
And so that's the kind of this golden group of people. They get a lifetime stretch. It kind of feels like the old rules. Everybody else, is in this next bucket. And the first, we call it maybe the silver bucket. They get a 10-year stretch. They get to take the money out over the course of 10 years. If the person who passed away had not been taking RMDs, they can decide what they want. Then the inheriting person can decide what they want to do. Take 0, 0, 0 and all of it. They could level it out. They could do a few different things. If the person who passed away had already been taking their RMDs, then someone who inherits it, even though they're under this 10-year rule, they need to take required minimum distributions each year, and then get the whole account emptied by the 10th year.
So just to kind of recap a little bit, because we've gone through, even just in this short time, we've gone through a lot of details. Yeah. So basically, if in fact you are receiving distributions from an IRA from your folks, from your parents, and it started prior to 2019, you're fine.
Yeah,
you're fine. That's not going to change. It's after that. So when is really important. The other thing is that are you an eligible defined beneficiary? Mm-hmm. And those requirements, those are very specific if you fall in the rules. So if your parent dies after a certain date, or your spouse dies, do you fall into this category? Mm-hmm. I haven't seen anything about marriage. I haven't seen anything in the rules. So I wonder if somebody's just living together, do they name their partner? Is that going to be qualified as an eligible beneficiary?
Yeah.
I don't know. I don't see anything in language that talks about it.
Yeah.
Marriage, it says a spouse.
Yeah, spouse. And in the rules, if they were, say your significant other was 11 years younger than you, they're probably going to get caught in this rule and have to go into the 10-year distribution. If they're 8 years younger than you, maybe you're fine. Maybe it's still functional. But that's a specific question that would depend on the specific situation.
I think there's going to be a lot of misinterpretation of this and say, well, we've been together for 20 years.
Yeah.
I'm a common law husband or common law wife. I don't know it. I haven't read the language, so I don't know specifically. And I think that's going to be interpreted somewhere in court.
Yeah, it probably will be. And so as we transition to the most favored group that gets a stretch, you get the 10-year group. And I would say this least favored group that only gets a 5-year stretch. And not to say you have to work to get there, but they've tried to make that a very small bucket.
Right.
It's usually mistakes. We've had clients where they've ended up there because there was mistakes. Before they came to us, they had set things up inappropriately. So that's kind of the framework. The piece that you just mentioned is really interesting of the trap. How are you going to get here? They've changed some of these rules on the penalties for this. A penalty for not taking an RMD, a required minimum distribution.
Used to be
50% is the penalty. So that's huge. To think if you had a $10,000 RMD that's supposed to come out, and then now you have to pay a $5,000 tax bill to the government because you forgot to take it. It's a massive penalty. And part of that is that my understanding is the IRS was not dedicating a lot of resources to enforce this. But if they caught you, if there was an audit, there's a very massive penalty. And so people would take the RMDs. Right. Well, what they're shifting as part of this whole framework is that 50% penalty has gone down to 25. So it's a 25% penalty. But on top of that, if you remedy it, if you notice it and you fix it within a reasonable amount of time, and there's some rules of what that is, roughly 2 years or so, but there's some other rules on that, it goes down to a 10% penalty, which in my mind makes it much more of something that people can remedy. If your CPA notices it, hey, you're older now.
And we've had clients who just through ignorance were kind of trapped, and they had to take RMDs from their deceased spouse or something like that. And immediately what we did is we got counsel and talked to a CPA and says, okay, what do we do?
How to best fix this? And I think, so you couple that, these decreased penalties with, they also pass a 3-year statute of limitations, saying, and there's some ambiguity there, but under the once you file your tax return, a 1040 for most people, when you file that starts a 3-year clock. So they've reduced the penalties, put in a clear statute of limitations. And then as part of this, 2020, 2021, and 2022, there's been a lot of waivers of these penalties because of the confusion they created.
Right.
So with that, if you have a 3-year statute of limitations, in the last 3 years, everything's been waived, it gets people in a position where they get to, not to say walk away clean, but they get to start doing it right for 2023.
And I think the most important thing we want to get across to you, the people that are watching this podcast and listening to us on the radio, this has changed, and it needs somebody to clarify it for you. If you have questions in your head, are my beneficiaries correct under the new law? And if you've been married maybe more than once, or you have children, you need to sort this out in such a way that it's clear for you what you want. And what I'm trying to get across is that if you've done your estate plan and you think you've satisfied all of your distribution requirements, that is not true. You have not. Beneficiary designation trumps an estate plan, and you have to be aware of what your beneficiary designations are. And you can't just name your trust, because that could be the worst thing you could do if it's not set up correctly. Make sure you have clarity, because if you don't, the IRS is going to take a big hunk of your retirement accounts out. Stay tuned for our next section. We're going to talk about updates in Medicare and Social Security.